come before the Court of the State of Ohio versus Jeffrey Palcisko. The state is appealing this matter. Mr. Palcisko has not filed a brief, so Mr. App.No, you will have 15 minutes in which to make your argument. Obviously, you don't need to reserve any rebuttal time. We have read your brief and we're ready to begin when you are. Please remember to keep your voice up because we are being visual about the recording.
Good morning, Your Honor. May it please the Court. Chris Immel on behalf of the appellant for the Village of Seville in this matter. We are here appealing the trial court's decision. The appellee filed a motion to terminate his ALS suspension in April 11th, 2019, 168 days after his initial appearance when he was arrested for an OVI and a refusal to submit to a chemical test.
And it's my understanding, at least from your brief, that the record will show that prior to that motion to terminate, there was never a motion for an appeal hearing on the ALS suspension. Is that correct?
That's correct, Your Honor. On October 24th, 2018, that was Mr. Palcisko's initial appearance in court. He filed a written not guilty plea on October 25th. Subsequently, he did file for limited driving privileges during the case, but no administrative license suspension appeal was actually filed, which is required through the statute. And it's very clear, the General Assembly has laid out in the statute that an individual must, at his initial appearance or within 30 days thereof, file the administrative license suspension appeal if they are to challenge that. Several courts throughout Ohio have determined that the administrative appeal is a separate, distinct case from the criminal case. They do not affect one another, and that a administrative license suspension does still exist if the case were to be tried and a not guilty verdict were to be had.
In this case, there's no precedent out there holding otherwise.
Correct. I would submit to this court that we had a suppression hearing on this matter. The trial court issued a lengthy decision on that motion to suppress. Ultimately, several of the field sobriety tests were deemed inadmissible. Based on that, we moved to dismiss this case under Criminal Rule 48 without prejudice, in effect having the same finding as a not guilty verdict at a trial.
How about the timing on that? Did you file a motion to dismiss before the 30 days had expired?
No, Your Honor. It was well after. The motion to suppress was filed well after the 30 days to file the appeal was conducted and expired. It's our position that the trial court, when it granted the appellee's motion to terminate the administrative license suspension, did so without jurisdiction and issued a void order. Therefore, we would be asking this court to reverse the trial court's decision and reimpose the administrative license suspension with the same time remaining from the date May 10th, 2019, when the trial court issued its order terminating the administrative license suspension.
So as we are here today, based upon that order, for however long that order's been in place, Mr. Palcisko's license has not been suspended.
That is correct, Your Honor. Since May 10th, 2019, his license has been reinstated. That administrative license suspension was terminated.
Did the court state any basis for its decision?
The court indicated in its order that there was no probable cause to arrest and therefore made the determination that the administrative license suspension should be terminated.
Which is in fact one of the findings the court can make.
It can, Your Honor,
In
yes.
an appeal hearing.
In an appeal hearing. Here's where the main issue in our position is had defense counsel filed that appeal appropriately at the time, we have that appeal hearing, we go through the statute as is required, the officer testifies as a de facto BMD employee as to the license suspension, the trial court then can terminate the license suspension. However, when there's no appeal filed, there's no civil action filed to terminate the license suspension. All we have is the criminal case. The courts are very clear that the administrative license suspension is distinct and separate and survives a not guilty finding in a criminal action.
Was appellate counsel the same person who was trial counsel?
Yes, Mr. Kucharski was trial counsel in this matter, although he did not actually file, I believe, an appearance, nor did Mr. Palcisko file anything in regards to this. But the appeal was perfected on trial counsel and Mr. Palcisko. Based on that, I would submit to the court that the trial court either issued a void order when it acted outside its jurisdiction, or it terminated the ALS on impermissible grounds when there was no finding as to, under the statute, under 4511-197, as to the grounds to terminate the administrative license suspension. I'd ask the court to reverse the trial court's decision and reimpose the administrative license suspension.
Thank you.
Questions? Thank you. All right, we'll take the matter under advisement, issue a written decision in due course. It will be mailed to you as well as opposing counsel, posted on our website and out at the Supreme Court. Have a good day.
Thank you.